Good afternoon and welcome to the latest in our series of free webinars. Today's topic is the last in a series of 6 peer review webinars. Today we focus on the family category. This is the 15th free webinar we've produced since March, with no sign of the virus going away. We'll be doing many more webinars over the coming weeks and months. We'll be offering training on topics such as third-party managed accounts, cybersecurity, confidentiality, enhanced due diligence, and conflicts of interest. Now, this Zoom event is in webinar rather than meetings mode. That means that we cannot see or hear you. Today's speakers, I'm very pleased to say, are Professor Avrom Sherr, Louise Garner, and John Platt. Professor Sherr is the principal architect of a system of assessment of legal competence known as independent peer review. Since 2002, this has been used as the system for assessment of the quality of publicly funded work in England and Wales. What is remarkable is that he has also designed similar systems in Chile, China, Georgia, the Netherlands, parts of Russia, Israel, Scotland and South Africa. He is currently chair of the Hamlin Trust and the Advice Quality Standards Project Committee. We have a current active peer reviewer, Louise Garner, with us. Louise is a director of Ott & Penner Family Law Solicitors. Louise qualified in 1985 and is a member of the Law Society Family Panel, the Law Society Children Panel, and the Advanced Family Law Panel. Louise undertakes all aspects of children law work, and in 2018 she was granted higher rights to advocate in the High Court. She became a peer reviewer in 2008 and has carried out more than 100 peer reviews. And then my colleague John Platt. John is a solicitor specialising in children and family law. He is widely respected as a legal authority in the Northwest region and provides expert coaching and advisory services to law firms seeking advice about peer review or legal development. For over 30 years, he was BBC Radio Manchester's Legal Eagle. He's been president of both the Oldham Law Association and the Association of Northwest Law Societies. John was chosen to be a senior peer reviewer and stayed as a peer reviewer for a period of 7 years. Now, just a word about questions. Please feel free to use the Q&A facility to ask questions. It's likely that we won't have time to answer all of your queries. We shall, however, answer all queries after the webinar and provide you with a link to the answers. We may overrun slightly. If we do, I'll point that out, but I'm not particularly worried if we finish a few minutes after the scheduled time, because unlike a face-to-face session, we don't have to worry too much about trains to catch, etc. But you're free to leave whenever you wish. Now, one of the most common questions we get throughout the webinar is, can we have a recording? Can we have the slides, etc.? Well, yes, the session is being recorded, and a link to the recording, together with the questions and answers and the slides, will be sent to you. So I'll now introduce you to Professor Avrom Sherr.
David, thank you. And welcome to everyone. I'm going to try and introduce the idea of quality to you and how we got to peer review. And there was a time when actually you might have thought that pressing any key would have given you the level of quality that the Legal Aid Board and the Legal Services Commission and now the Legal Aid Agency were looking for. And we started all this some time ago. We began with something called transaction criteria. Some of you may know about that. But our aim was to produce a system that would actually understand quality from the point of view of lawyers, but also from the point of view of clients. So we came up with a major piece of research in the late 1990s. We looked at over 142,000 cases, 83,000 of them completed. What we carried out was what is now usually referred to as a randomized control trial. We had some different payment groups. We looked at different models of assessment, a statistical model, which was briefcase, peer review, which of course, as you know, we've moved into as our major approach, model clients, and also client survey. All of the things that we were doing were really aiming to bring together all of these elements of quality. First of all, I suppose inputs, that's everything that goes into your firm before you actually start work, equipment, the IT, your library, the qualifications of your staff, etc. All of those are essential and important. Structure is the way in which you manage all of those items that comes in. And these elements are looked at by all sorts of systems of quality assessment. But the next element is one which is much more difficult. That's looking actually at the performance of your work, the process, the advice, fact gathering, correspondence, practice management, strategy, advocacy, etc. All of those things much more difficult to gather, and therefore the file becomes a very important way to get at these issues. But we also want to see how successful you are in terms of the outputs which you manage to succeed with. But the problem in law is that outputs can't easily just be looked at in terms of numbers, because no one case is similar to another case. No one judge is like another, and what they have for breakfast or lunch is always different, and the other side is always different. So one has to actually look at each case in order to understand the outputs and the worth of the output in relation to each case. So looking at files in relation to all of these elements seems to be the right way, and that's how, as you know, we have gone. So in the quality and cost research, we actually were looking at a second aim to put peer review into practice with this number of cases, this number of people who are firms who are contracting these different work areas. And we found that the difficulties were selection of peer reviewers, training them, what criteria they would use to make judgments, the sample that would be selected from which they could make judgments, and monitoring of all those afterwards. We found the reliability of the criteria of the reviewers, also of the reviewers as each of them did their work, and how similar it was to everyone else who was reviewing. And we thought in the end that it was better to rate law firms rather than individuals who were working on cases, because the management of the firm should also be enabling proper supervision, correct handing out of work to the right people. And we concluded that everything should be double marked, and it should be the whole organization only. Well, I think you'll know that the only cases that aren't double marked are the ones where 4 and 5, that's failures, are found. But we do look at the whole organization. So what we've got is really something like an X-ray of the firm by looking at all these files. It isn't the same as surgery, but it's close. The results were that we saw in quality and cost that there were major differences between solicitors and the not-for-profit. We saw 3 peer reviewers who were really rather strange. One used to mark everyone high, one used to mark everyone low, and yes, you probably guessed it, one used to mark everyone at the middle. We had to make very sure that what they were doing was sensible. We found all sorts of interesting differences that enabled us to see from peer review that we could actually work out what was going on. It was difficult for anything to be hidden when we looked at the actual files. We also decided to send out model clients. There were 45 such visits. And from these people, we learned much more about issues from the client point of view of access, the quality of the advice and the immediate follow-up. And that was very helpful in terms of deciding how we would go about assessing the work. Because there were lots of things that the model clients could really tell us about. And we could actually see from the way in which they were given information, how good that information was from their point of view. So we could look actually at the brains of the clients and what they'd taken in. And what our peer reviewers found out when they looked at what the model clients had received and what they thought was that advice was often inaccurate, impractical, it was woolly, it could be confusing and contradictory, and it could be inappropriate. So when we look at files, we try to look at them thinking in some way what the client would feel if they got that sort of answer and that sort of advice. But we were very clear that just asking clients was not good enough. So here is a very good example of that problem. The model client thought that the advisor was impressive and really helpful, very understanding. Overall, it was very helpful, reassuring and personal, but the peer reviewers had a different view. Although very clearly empathetic, this advisor does not really know enough about the law to be using legal aid money. A good example of touchy-feely advice. And so we decided it was necessary, of course, to have both, quality interrelating. We need to know exactly what a lawyer thinks is good, but we also need to understand what the client receives. So we ended up with about half of peer reviews being carried out on a random basis, and the other half actually being targeted in the sense of firms which the Legal Aid Agency or previously the Legal Services Commission considered needed to be looked at in some way or for some reason, either because they had a large take from the pot or for some other reason. But they, that's the Legal Aid Agency, they make the decisions who are going to be peer reviewed. We said there should be sensitive implementation, and actually for the first 16 years or so of peer review, nobody was taken out of the system as a result of bad peer reviews. But I think you should understand that there is a very big difference between the transaction criteria and the compliance elements of quality, which are looked at by others in the Legal Aid Agency. We are looking at what a lawyer would consider is a good job. But these still were and are the same major issues for us in terms of peer review, selecting the right reviewers, training them, which is considerable, choosing the criteria on which they would base their decisions, the sampling of cases, and then monitoring all of those reports that come through. That's the world of peer review as we work it through. And it's been used in many ways. It's been used for a large number of types of case. And some of these, I think you'll probably be aware of. Used to use it with all family cases. And sadly, since 2013, we've only been able to use it for the small number that deal with legal aid. And of course, legal aid has become a much smaller area of work in general. So I mentioned the criteria that are used, and you will, I think, know about the gradings that we actually grade everyone with. Competence means a pass. Anything above that is really very good. Competence plus. We rarely get ones nowadays for reasons which I think you will know and are pretty obvious in terms of the amount of money that you get for legal aid and how difficult it is, and especially in current circumstances. But we have had some ones, and that's good, even in the last 6 months. There are a number of 4s, not that many, but there are some. There are few 5s, total failures in performance. And if you look at the process paper, which is on the Legal Aid Agency website, I think you'll find even more details about how all of this works. So the criteria which are looked at are graded pretty much in the same way as this. They have to circle, the reviewers circle one of those for each of these questions. And these are the sorts of questions which are used. It's one section on communication with the client. Has the advisor understood the problem? How effective were the communication and client handling skills? How effective were the fact and information gathering skills, etc.? And how effectively then was the client informed? So communication being 2 ways of the merits and all developments. Then there's the advice. How legally correct was it? How appropriate was it to the client's instructions? How comprehensive was the advice? And I'm going to show you the family criteria, which are slightly larger in a moment. And then was the advice given in time and at the right time? And then in the 3rd section, the work or assistance that's carried out subsequently on the file. If there wasn't any other work apart from initial gathering of information and advice, was this appropriate? If there's further fact-finding, was that appropriate? Was it efficiently executed? And with any other work, similarly, how appropriate was it, and was it efficiently executed? How effective in working towards what the client reasonably wanted or needed was any further work carried out? If no disbursements, was this appropriate? If there were disbursements, were they appropriate? Where it's necessary, did the advisor consider and advise on an effective referral? So throughout the file, how effectively did the organization use resources, and did the advisor or their work in any way prejudice the client? Well, this was something we didn't put in originally, and it was the peer reviewers who felt it was necessary, because they found that, and this is overall, and these numbers are from a few years ago, in about 8 or 9% of cases, there was some actual prejudice. Family has this extra element in relation to different parts of it. How comprehensive was the advice in relation to divorce, if that's still within elements which might still be within the system? How comprehensive in relation to children, to ancillary relief, to injunction and advice overall? So these are the criteria, and then there is an overall mark, and the overall mark is not simply an average of all the other marks. Neither is the overall mark for the firm an average, but reviewers are to use their own judgment about how well the firm does, and it's an absolute that every client should get a competent service. So it's not really possible to balance bad work in some areas with good work elsewhere. There's also specific criteria guidance for each discipline, and the reviewers have that, and that's also to be found on that website. Thank you for listening to me. I'm going to hand over now to Louise Garner, and she will tell you the real stuff. Louise, you might need to unmute.
I pressed the right buttons before, but of course now I can't press the right buttons. Here we go. Okay, well, my name's Louise Garner and I'm a practicing solicitor. I'm also a peer reviewer, and I thought I would tell you how I became a peer reviewer. I had a peer review, and when I looked at the answers, I thought, I'm not sure I like that. And there was an advert in the Gazette which said, do you want to be a peer reviewer? And I said, yes. It's quite a lengthy process. You have to complete the application form. And if we meet the criteria, then we have an interview, and then we have a peer review of our own files. And if we're appointed, we have our first few reviews moderated by more senior reviewers to check that we're doing them properly. Over the period, we have annual training with Avrom and others to look at any concerns and any changes that have been raised, and also to check the consistency between the reviewers. And equally, we continue to have regular ongoing peer reviews of our files as well. One of the things that I'll bring to your attention is the guide, Improving Your Quality in Family. I make no apology for recommending that you read it and action anything that you recognise. So, how do we review? I can say that I've never gone into a review looking for problems, although sometimes they're self-evident. I'm conscious that we're all under various constraints, but I'm looking at whether there are ways to improve the quality of the work done for the clients. I am anxious to highlight the positives, but I have to address any negatives as well. What do we look for on the files? You'll see that I've written the word evidence. Avrom's shown you the questions that we have to answer in the civil criteria checklist, and we have to look at the information that's on the file to do this. It isn't a tick box exercise. I review a file fully before I consider the ratings that are appropriate for each of the questions. But when I do review a file, I can only do so on the information that I can see on that file. If there's something that isn't there, it can't be included in the review. So you may know that you take full instructions from each client, but if it isn't clear on the file, the reviewer can't include it. You may be clear that you've advised the client about the law and about other matters, but if it's not evident on the file, it won't be included in the review. So there must be evidence on the file that of all the things that have happened and that have been said. So I'd look for evidence of instructions given by clients. Have they been checked with the clients? Have all ancillary matters been covered? And how can this be seen? One of the criteria is in relation to advice. So I look at the advice that's been given. And if it isn't written on the file, I don't know what it was, and I don't know whether it was correct. So to form part of the review, the matters must be evidenced on the file. They need to be in writing. If they're in handwriting, that's fine, as long as it's legible. But if I can't read it, I can't guess what it says. That may seem to be a bit flippant, but what happens if someone else has to pick the file up? How will they know what's been said if it's not clear? So the advice section we look at especially, and is it relevant to the client's needs? Standard paragraphs and leaflets are very useful, but one of the things we look for is whether it's tailored to the individual clients. A lot of leaflets and standard letters could be quite confusing, especially when the clients are vulnerable. I need to be able to see that the client has had proper evidence about the law, about the merits of each matter, and that it's done in a way that they can understand. So what does a peer review entail? We start off by being contacted by the peer review team with proposed dates of the review and the name of the firm to make sure that there are no conflicts. It says we're provided with 15 files, and they come in boxes, and they may be 2 boxes, or the most I've ever had were 20. There's usually a mix of certificated files and legal help files, and we have to review 12 of them. We can't choose. We can't choose which ones we do. We can't choose the smallest or the ones that look most interesting. We have to start at the top of the list. And unless there's some reason that one of the files can't be reviewed, we simply go down the list. The reason that we may not be able to review a file is because there may be papers missing from a file, or not all linked files have been provided. You'll be asked to provide all linked files, and please do so. These might be legal help files before the file became certificated, perhaps where there were PLO proceedings before care proceedings, or it may be the certificated file that followed on from the legal help file. It's very difficult to review a file properly if we don't have all the information, and that information may be in the linked file. And again, we can't guess at what happened. So we review each of the files. There's a spreadsheet that we have to complete with the ratings for each of the 12 files, and out of that comes the overall rating for the review. We then have to write a report which sets out the positive and the negative findings. and with examples to show how those have been identified. Within our annual training, we've discovered that there are often different headings used by the reviewer, but the things that are set out are very similar. So the first heading is positive findings. They could include good communication with the client, prompt action, proactive work, and perhaps good outcomes. Then we go on to the negative findings, and there's a range of negative findings to look at. The first one is major areas of concern, and those are the things that are a real detriment to a client. So that may be advice that is wrong, deadlines that have been missed, those sorts of things. The other areas of concern and areas of development perhaps could include delay that could have been prejudicial, correspondence not responded to, and other things like that. There's then a heading of further comments, and I find that often that's correspondence from other files that's in the file, things that shouldn't be there. The report then concludes with the suggested areas for improvement, and that's the bit looking at the aim of the process to improve the quality. So there are other areas I could cover, and overall, whilst a tidy file may not automatically receive a better rating, it will be much easier to review and will be much more likely to go to meeting the criteria for the quick pickup test. Could someone else other than the fee earner pick up the file at short notice, such as for an urgent hearing, and represent the client properly? Is all the information needed there, and can it be found easily? I think for me, if there's one thing to take away from today, as well as to read the guide, it would be the word evidence. Make sure anyone, including a peer reviewer, can find easily what's been done and said to be able to progress a file or to see the quality of the work on that file. Examples of good and poor practice. I'm going to leave those to John mainly, but certainly I need, if you're going to write an attendance note, 2 sentences is not going to give me the information I need. I probably don't need lots of pages, but just make sure that all the information is there. Make sure that your advice is documented, make sure the processes are documented, and make sure that there are anything that's been done on the file I can find when I'm reviewing it. Thank you.
Thanks very much, Louise. I think it's my turn now. My name is John Platt. I'm now a retired solicitor, so I've escaped the pressures and the stresses which you all will be suffering, but I'm afraid as you get older, it's just replaced by other stresses. I'm going to talk a little bit about good and bad practice and comment also on standard letters and other standard documentation. In relation to good and bad practice, in some respects, they're 2 sides of the same coin, in that bad practice is not doing what you should do, and good practice is not doing what you shouldn't do. In essence, the concept of good practice is the same as it always has been for lawyers for the last 100 years. There are 3 essential aspects to good practice. Firstly, taking and recording comprehensive instructions. It's no good chatting to the client about the weather or where they live or their football team. What you need to do is to spend the time with the client taking and recording the client's instructions, and they should be as comprehensive as is reasonably possible. Secondly, having heard what the client's got to say, you need to give good comprehensive advice, and again, make a note of that advice. A note in the file, and later in a letter or an email or a written message to the clients of what that advice is. Finally, and the obvious thing, and probably the thing that most members of the public think is your only job when you're acting for someone, and that is to conduct the case efficiently, hopefully successfully, but that isn't always the case. And whatever you do in a file, as Louise has mentioned before, there has to be written evidence of that. There's no point in doing the most wonderful things for a client or working for a client's case if you've not got evidence of it in the file. Now, I've mentioned the three essences of good practice, but there's a fourth obvious one, and which is referred to throughout peer review, and that is that there must be good, effective, and relevant communication with the client. It's no good being the best lawyer in the world and taking the best instructions and then failing to communicate to the client about the progress of the case, your advice to the client, and telling the client how they should conduct themselves in the future. Now, attached to this bundle, and it's on the screen now, you'll see an example of an initial attendance note. I should say that there is no one, as far as I'm aware, called Deborah Bradshaw. This is purely hypothetical. My wife is called Deborah and our neighbours are called Bradshaw, but they're not connected in any other way. I've included this example of an attendance note because I want to get home just how important it is to take full comprehensive instructions. Now, Deborah Bradshaw in this case has attended just because she's decided she wants to get a divorce on the grounds of her husband's unreasonable behaviour. And you'll see from the attendance note that the fee earner has explored all sorts of other aspects of her family relationship. The fee earner has not constrained herself just to look at the evidence that she needs in relation to a divorce. Now, I must say, in terms of peer review and in my experience since then of looking at firms of solicitors, I do find this is a very common fault, particularly in relation to domestic violence cases. I find that firms undertaking domestic violence cases quite often confine themselves simply to looking at the evidence relating to the domestic violence. They don't explore problems in relation to the children. They don't explore problems in relation to accommodation. They don't explore the possible involvement of social services. It's most important that when you take instructions and you prepare a detailed attendance note, that all avenues, all areas of concern are explored. I should add that when a peer reviewer undertakes a peer review of these 12 files, which Louise has described, and they do come in a large number of boxes, the files are taken out of the boxes and the peer reviewer will look at the first one on the list of files, open it up, and if my experience is anything to go by, the first thing that the peer reviewer will do is look at that initial attendance note and that initial letter to the client. If that initial letter is comprehensive, if the initial attendance note is comprehensive, then the peer reviewer is going to approach that file on the basis that this is a good firm. This is a firm that looks for problems and then looks for the problems which may exist and which does its job properly. So the initial attendance note and the initial letter to the client, I believe, are probably the most important single documents that will be in any particular file. And I can't overemphasize the importance of those two documents. And that's why within this bundle, which I think is between pages 35 to about 40, you'll see these sample attendance notes and a sample letter to the client. The other thing which I discovered when I was peer reviewing, and which I think is an excellent idea, and I commend it to everyone, is that if you prepare a proper attendance note, like the one that's illustrated here, you can send a copy of that to the client. And if there's anything wrong in it, the client can let you know immediately. So that has the double effect of advising the client and also making sure that you've got the instructions down correctly. Because as you know, clients are sometimes pretty nervous, pretty excitable, and may not say everything, or they may say something which isn't completely accurate. I don't want to sound too formalistic about this, because it's important to remember that at the heart of peer review is a concern that the client has been properly represented. It's not a quality assurance project, peer review isn't. peer review is intended to raise standards to a point where the client has been properly served, that the client has not been placed at risk of prejudice. Avrom referred to the introduction at the request of peer reviewers to the concept of, has the client been placed at prejudice or at risk of prejudice? It does happen, and the figure that Avrom mentioned, was it 14%, something like that, of files were identified as where a client has actually been prejudiced or placed at serious risk of prejudice. And it happens in all sorts of ways in a file. So it's most important to not simply to regard peer review as a box-ticking exercise. Peer review is intended to provide a system where good practice will ensure that the client is properly advised and properly represented. Now, the best of advice and the best of expertise is of little use if communication to the client is inadequate. What I found was in the very first file, very first firm that I reviewed, this was a long time ago, but having looked at numerous files since then, I don't think things have necessarily changed for the better in a number of cases. I picked up a file and the first letter of advice to the client contained 27 pages. It included all sorts of information about the firm's terms and conditions, all the client care requirements, which the old franchising criteria required. It had all sorts of information. Very little of that information was relevant to the client. Now, 27 pages is quite a lot. It's like an encyclopedia to somebody who cannot speak or read English. And as I looked through the file, I noticed that at that first attendance, the client had been there with an interpreter. She couldn't understand or read any English at all. So the firm in this particular case had thought that it was satisfactory to send 27 pages of what amounted to a large extent to gobbledygook to somebody who would never be able to read or understand any of it. So although they ticked all the boxes as far as quality assurance requirements were concerned, that amounted, in my view, to bad practice. Far better to have sent a succinct letter explaining what was happening in simple terms. That was a fairly extreme example, but I often, when reviewing files, and since then when I've looked at or advised firms on how they should conduct themselves, I've seen client care letters going to clients or client information letters going to clients containing all sorts of irrelevant information, the most common of which I found was the private paying clients' expected charges. So somebody who has the benefit of legal help or a public funding certificate, somebody in a care case, for instance, would receive information saying that the charging rate for the firm was £180 an hour or £250 an hour, that the expected cost of a divorce would be £563 or however much it was. All of this information was irrelevant to the client, but the client, although they may have limited ability to read, they were able to pick up on numbers, on the amounts involved. So they were left with the impression that although they'd been told they were getting legal aid for this case, they were going to end up paying a fortune for the services which the firm was going to provide. That was bad practice, and it continues to be bad practice. So a word of advice, root through your files and check those standard letters of instruction, standard letters to the clients, those standard bits of information which you send, and make sure, as Louise said, that they are tailored, that they are adjusted, that they're edited to meet the needs of your particular client. I don't want to say that standard letters are bad things. They're not. They can be very useful, and they're certainly here to stay. I think of far more benefit are standard information sheets, for instance, telling clients about procedure in relation to divorce or care proceedings. I think that standard information sheets informing a client about how long a case is likely to take can be very helpful. But please, please don't do standard attendance notes. I've reviewed firms and I've seen files and files where the same attendance note with the same paragraphs is in every file. Now, I'm sorry, but a peer reviewer picking up 12 files, each of which containing the same notes about the client is concerned about her husband or concerned about her partner, in fairly bland terms, is of no use. And it leaves the peer reviewer with the inescapable conclusion that the discussions which are described in the attendance note may not necessarily have taken place. So standard attendance notes for me are a no-no. Standard information sheets can be extremely helpful. I can see I'm running out of time. We're getting near to 1:45, and I know that we want to leave at least 15 minutes for questions. So I think probably I will.
You're actually okay, John. Just to let you know that we haven't had any questions. So sorry for interrupting, John, but if anybody wants to now start using the Q&A button, please feel free to do so. Sorry, John, back to you.
Well, I was just reaching, you just take the words out of my mouth. That's more or less what I was going to say. I would like to just mention one area of work which I've touched upon, but which I've found was particularly illustrated both the benefits and disadvantages of standard documents, and also provided examples of good and bad practice. And that is in firms which concentrate primarily on domestic violence cases, sometimes which have been referred to them from outside agencies. There seemed to be an over-concentration just on the domestic violence and seeking a remedy for that. That's not to say it isn't important. Injunctions were often obtained, or almost always obtained, within a very short and very efficient period of time. But in almost every case, there were children involved, and in almost no cases was there any proper or adequate advice or conduct in relation to the case in relation to those children. That meant that although I can think of one case, that although favourable outcomes were obtained in pretty well every case that they handled, they ended up with a below competence assessment of 4. So although they had 12 good outcomes or thereabouts, the assessment was that they were not doing their job competently. And that was because they did not explore other aspects of the case. They didn't look at the effect of the client situation on the children, or they didn't look at the effect of the situation on the client's accommodation, long-term accommodation plans. Domestic violence cases I found were an excellent example for illustrating good and bad practice. Having said that, I leave it to you to ask whatever questions you think are necessary or helpful. David?
Yeah, I'm here. Okay, so we've got a couple of questions. The first one is, will the handout be available along with the link to the seminar? And the answer is yes, of course. We will be sending out the handout and the link and any Q&As. The next question is, are you required to provide cost information in relation to care proceedings when they are very unlikely going to be responsible for the costs, unless in the unlikely event that a certificate is revoked? I mean, I could answer it, but Louise, do you want to answer it?
Yes, I would expect to see some costs information on the file. I certainly wouldn't expect it to be particularly extensive, but I think you need to refer to it. Would you say different, David?
No, I'd say you have to provide cost information. Let me give you a clear illustration why. I remember one of our clients gave cost information but didn't give cost information regularly, and there was a question mark over whether or not the client should have got legal aid. It was either the client or the other side's client, because the problem was that the other side said that he had raised a lot of finance through credit cards and had hidden some of his income. So what happened was that the legal aid certificate was revoked, And I think costs of above £100,000 had been incurred at the time of the certificate being revoked. And of course, then things got very awkward in terms of who's liable to pay that. And generally speaking, it would be the persons whose certificate had been revoked, but I don't think that ever happened. So I think from a protection point of view, protecting yourselves as lawyers, you do need to ensure that your team understand clearly when cost information should be provided and how often it should be updated, and indeed why. Generally speaking, it's much more important where it is a legal aid certificate compared with legal help for fairly obvious reasons.
But I think the question related to non-means tested public law proceedings.
Oh, in which case, sorry, I didn't appreciate that. I beg your pardon. When it's non-means, non-merits, then there's an exemption, and you don't have to provide that.
I mean, it's quite helpful to provide it, but I remember sending a letter to somebody about the amount of costs in a case, as we're expected to, and it wasn't a care case; it was a private law case, and there was no chance of the clients ever having to pay any of the costs because there was no money available. But I think the figure said something like £3,000 had been incurred in the case. And the next day he was in the office saying, 3,000 quid, I want some of that. Why should you have 3,000 quid for my case? So you do have to phrase the costs less sensitively where they need to be sent. But in public law care cases, I never used to send cost letters. And certainly if cost letters are omitted from a public law, non-means tested, don't forget, not all parties in care proceedings are non-means tested, but in non-means tested legal aid, no one's going to be criticised for not sending any information about costs.
Yeah, absolutely right. Apologies. Yes, non-means, non-merits. There's a clear exemption. So thank you for that clarification, John. I've noticed that some of the questions have been put in the chat facility rather than Q&A. So I'm just going to refer to that. So we've got a question here, and this is one for Louise. How are files being dealt with at present when much of the work is being done electronically due to the pandemic?
Well, currently the files are still being provided to me in paper form, so I would expect that means that you'll have to print off any work. There is consideration and work at the moment going on about being able to deal with files electronically in the future, and there are some electronic files that have been reviewed, but I think that tends to happen less in the family sector than it does in other sectors. I think Avrom will have some information about that.
Yeah, certainly there are full digital files being looked at in some areas. Quite problematic to review. The difficulty is that when firms, as it were, dump everything into one large file, and it's not in the usual organized or structured set of different papers, then it becomes very difficult to try and work out how to review it. So if you're preparing a digital file, it would be very sensible to use the same sorts of headings and distinctions for the types of paperwork that you would do if you had a paper file, because that makes it easier to review and for anyone just to pick up from outside.
Thank you for that, Avrom. I've got one other question here, which I'm going to ask Louise first and then John to add any comments if he has any. And that question is, if advising a domestic violence client, how far does children advice need to go, given it may not be in the scope of legal help?
I would certainly expect there to be some information about the children on the attendance note. Obviously, in terms of advice, then yes, you may not be able to advise fully in respect of the children, but I certainly think that if you're looking at domestic violence, then you would certainly need to look at the effect on the children and whether they could be included in any application that it might be appropriate to make. So initial advice, if not going any further.
Okay, thank you. Got a couple of other ones that come in through the Q&A facility. And I think, Louise, I think you've answered this really, but could you confirm whether or not you have a preferred layout of the files?
No, I don't have a preferred layout. Obviously, each individual firm lays out their files in the way that they find most appropriate. I have no preconceived ideas. I just need to be able to find things. So if I am looking at the progress of a file, if I've got correspondence which is not in chronological order, that creates all sorts of difficulties. I have no preference as to whether attendance notes and hearing notes form part of the main file or whether they're separate. I just need to be able to find things.
David, if I could add that whenever I used to peer review, what used to irritate me were files which contain numerous copies of the same document. That when the file, I mean, I do appreciate that when you're running a case and you make lots of copies of things and drafts are sent back to you, that you don't always have time and it isn't appropriate to throw away superfluous copies. But there were files with 20 and 30 copies of statements which were completely unnecessary, and it just made the job of the peer reviewer that much more difficult to rummage through to work out which ones were part of the file. And also it did suggest a level of management incompetence, file management incompetence, that somebody hadn't felt able to make a decision to throw away documents which were superfluous. There's one other thing which I should mention, and which I do advise everybody else to think about, everybody listening or watching to think about, and that's this. Whenever you close a file, and certainly before you send the files off for peer review, do check that no letters, attendance notes, whatever, from another case have crept into the file, because they do sometimes, and that's quite a serious breach of confidentiality, because the file is going to be disclosed, may be disclosed elsewhere. The client may ask for the file back again. They're entitled to it. And if there's a letter concerning another case, then that's quite serious. So do check through each file to make sure that there isn't stuff from another case left in it. It does happen. I should think it's happened, and every file review I've ever done, I've found a piece of paper somewhere that shouldn't be there.
That's a very useful tip. The only thing I would add to that is that I wonder to what degree peer reviewers are influenced by just how organised the files are, because I noticed one particular firm that they had different colour paper for different things. So attendance notes would be on one colour, letters would of course be on white paper. You'd have a different colour for telephone calls. File reviews would be a very bright pink colour, etc. And it, for some reason, just made it quite easy to find things and follow the correspondence clip, etc. And I don't know if there's any psychology involved in that, but if your job's made easier, Louise and John, do you think that does have any influence?
Well, I think I said it wouldn't influence me. But as you said, psychologically, if I find it easier to pick up a file, then that to me is a positive, because somebody else in the firm would find it easier to pick up the file. And that's one of the things that I'm looking at, because to be able to represent your client positively, especially in a family matter, somebody else may have to do a hearing at a very short notice, and they need to know where to be able to find things. So no, not consciously, but as you say, potentially subconsciously.
I mentioned.
I think also, sorry, Dave. I think also it suggests a level of competence in terms of file management. I think what you were describing suggests possibly obsessive, some sort of obsessive compulsive disorder. But generally speaking, a tidy file will suggest that the person conducting that file takes its management seriously. Whereas somebody who simply throws bits of paper into a file, you think, well, how good are they at their job if they're not sorting things out properly?
Can I add? One of the things we say right at the beginning is this is not a beauty parade. So if everyone goes away and starts colouring in all the different areas of their files, please do not expect that is going to make it. It is absolutely clear that anyone picking up someone else's file needs to be able to work their way around it. And someone from a completely different firm with different expectations, different systems within their own firm, obviously is going to find it easier, if it's easier to do so, to work your way around the file. But please do not feel it's a beauty parade. It really, really isn't. And rather spend time on doing the work well.
And Louise, we mentioned file reviews, and how important do you think file reviews are in the context of getting a good peer review grade?
Again, if there aren't file reviews, that wouldn't stop me saying that the work hadn't been done properly. But if you look at the patterns of some of the negatives, things have been missed, or things haven't been done on time. If there were more file reviews, you would look at then the information that was on the file, and some of the things that may come up as negatives, even small ones, would have been picked up on a file review. Often, and I will say often, that in the suggested paragraph at the end, I may find a file review on one file. I find lots of peer reviews with no file reviews whatsoever. And often I will say, if there were more file reviews, you may find that the quality of the work improves.
Okay, I just remember on one peer review report, the peer reviewer in the positive comment section was said that they very much appreciated the fact that the file reviews were done thoroughly and reference had been made to the peer review's guide to common issues in terms of the common findings. So I think that was quite an interesting point. We have a couple of questions here. I'll put them together. One is really more of a point than a question. Have peer reviewers considered it's not always practicable or cost effective to print electronic files? Some files are voluminous. And then there's another question. Are legally aided clients entitled to their file if they request it in private public law children matters? Either Louise or John, would you like to?
I think mine, dealing with the second question first, I think clients are entitled to their files. They belong to them. The fact that they're publicly funded should make no difference at all. If a client asks for their file, yes, my view was always, somebody correct me, this isn't a peer review question, it's an SRA question probably, but my understanding is that clients are entitled to their file, subject to the normal conditions about whether the costs have been paid. The solicitor can hang on to it. As far as the first question is concerned, yes, it does cost money to print off voluminous files. And by the time the file is peer reviewed, you've been paid everything that you're going to get for the file. So it is a cost that you're going to have to carry. But until the system changes, I'm afraid you're stuck with that.
And I also say that that's not something that we as peer reviewers have any control over whatsoever. We review what is put in front of us in whatever version it's put in front of us.
We are trying to move over to digital files. That is, the legal aid agency is trying to move over to a system where they can deal with them. But as I said, it's just terribly important that they are organized properly in the way in which they are saved into whatever system you're asked to put them in.
Okay, thanks. I think we'll probably add to that question about whether clients are entitled to their files, because there are some unusual scenarios where they're not necessarily entitled to the whole file. So what we'll do is we'll provide a pretty detailed written answer on that one. I'm just checking to see if there's any final questions. I don't think there is. I'm going to sum up in a moment, unless anybody wants to say anything else before I conclude. No?
Nope.
Okay. Well, I'll conclude then by just saying that thank you so much for attending today's webinar. We enjoy delivering these webinars and would be really pleased to hear your feedback. So if you did appreciate today's webinar, I'd be delighted if you would leave a review. My colleague Ali is going to send you an email, and you'll be able to provide feedback to us if you would like to show our to show how grateful we are. If you could give us feedback, we will send you a free detailed family file review form which addresses the common issues listed in the Family Peer Reviewers Guide, which we hope in some small way will help to pass the peer review assessment. So once again, thank you for attending, and I hope you have a good afternoon and evening. Thanks very much and goodbye.
Thanks very much.
Bye.